Hi everyone and welcome to SEO Explains. My name is Shalom Gauri and today we're going to take a closer look at the Supreme Court's latest move towards ensuring speedy and proper administration of justice. If you're someone who's familiar with the way courts work in our country, you've probably noticed how each day begins with a cause list. That is, a list of items to be heard on that particular day. You'd also know how each item could take anywhere between 2 minutes to an entire day to be heard. It's not always predictable, and having a sense of how long oral arguments could take could help benches schedule their day in a more efficient manner. On 29th December, the Supreme Court Registry issued a new standard operating procedure in order to address this challenge. It applies to all post-notice regular hearings and mandates that all arguing counsel strictly adhere to fixed timelines. There are 3 aspects to this SOP. First, written submissions have to be filed 3 days prior to the hearing. Second, written submissions cannot be more than 5 pages long. And third, a day prior to the hearing, lawyers have to file a note specifying the time required for oral arguments. In our newsletter last week, Senior Associate Editor V. Venkatesan observed that it's easy to see why counsels would resist these time limits. After all, speedy administration of justice must be balanced with the right to be heard. In 1984, the 99th Law Commission report concluded that it was unwise to prescribe rigid and mathematically precise time limits. It recommended time estimates instead. The report also quoted eminent jurist H.M. Seervai, who warned that strict time limits could become an outrage if they prevent lawyers from completing their submissions. Seervai said that short oral arguments could work only if they were supported by extensive research and clear-cut work calendars like in the USA. In India, lengthy oral arguments often make up for scattered records, capacity strain, and incomplete briefs. The Law Commission report of 2009, however, moves closer to the logic advanced by the recent SOP. It recommended a 1.5-hour cap on oral arguments and, like the SOP, pushed for oral arguments to be supplemented by written submissions. This will allow for targeted clarification rather than full-scale narration of the case. Chief Justice Suryakant also has another rationale for this move. Lengthy arguments by resource-heavy litigants with access to senior lawyers should not eat into the time of ordinary and poor litigants. As always, the impact of this SOP will depend on how benches are able to enforce adherence. Particularly in more complex matters, will time limits be negotiable? For litigants without the benefit of senior lawyers, how far will the court go to protect them from procedural disadvantage? All we can say for now is that the court has finally taken a step to match their words with action. For more insights on the latest news from the Supreme Court, make sure to subscribe to our weekly newsletter. Thank you for watching and follow SEO for more.